Lawyers, what is the strangest or oddest law that's won a case for you? Story 1. I had a case where a guy was charged for running a red light. The thing is, he had been sitting at the lights for 5 minutes and it hadn't changed. The wording of the specific section under which he was charged related to stop signs and traffic lights and referred to them as traffic regulation devices. I successfully argued that as the traffic light wasn't changing, it wasn't regulating traffic, and he got off. I couldn't believe it when the judge ruled in my favor, neither could the police prosecutor. Just one of those things that hadn't come up before, I suppose, and it was a sufficiently rare scenario to not have been accounted for in the act. You'd be surprised how incompetently drafted some legislation is. Story 2. The weirdest case I have ever dealt with was Jolie v. Paul Atier, 1999, OJ number 1728, SCJ. I did some research for this case when I was a law student. Some background. This was at a time when the Ontario Court of Appeal had held that, if there were any factual matters in dispute, a case could not be dismissed on summary judgment. That is not the case today. It was discovered that this position basically ruined summary judgment as a useful process, but it was at the time. In such a motion, all facts alleged by the plaintiff would be assumed to be true. What happened was this: a man sued, among others, the College of Dental Surgeons, for persecuting him and interfering in his ability to live as a generic Martian. The plaintiff claimed he had been cloned from space debris NASA found in the 1960s. He claimed he had a genetic test to prove this, but it had been falsified by the CIA as part of the conspiracy against him. Well, naturally, this claim raises the concern that the plaintiff was bonkers, but there was no evidence, aside from his bizarre claims, of that. In court, the case was decided on 2 alternate grounds. First, on the boring grounds that the case was patently frivolous and vexatious because it was absurd. However, it was also decided on the more entertaining basis of standing. Justice Epstein held that only a person could commence an action in Ontario. The rules of civil procedure define a person to be either a human being or a corporation. The plaintiff's whole case was based on him being a Martian. If he was not a Martian, his case had no merit. If he was a Martian, he lacked standing to commence a lawsuit in Ontario. In short, we now have precedent that Martians cannot sue in Ontario. Story 3. Law student working at law firm. We have a fax machine that gets tons of spam faxes. Our chief partner has a vendetta against spam, and he uses it to give us practice in researching and writing petitions. So we catalog each fax, send replies to take us off the list, document everything and wait for them to fax us again. Then we follow up with a FCC complaint and demand letter. A couple times this has ended up with the person getting mad and sending us retaliatory faxes, black sheets of paper. If they stop sending, we don't do anything, but we've gone to small claims a couple times and gotten $500 per page a couple times. We also got someone trying to sell drugs through fax, but we just turned that over to the police. Story 4. The Canadian Interest Act specifies that all interest must be specified in a per annum percentage. If it is not, it's struck down to 5%. Simple interest per year. The number of lenders and creditors who try to pull off a 4% monthly compound interest, but aren't familiar with that provision of federal law. Shady outfit offers to sell you a used car with an interest rate of 3% per month. Neglects to mention that it's 36% per year. Debtor makes payments that they think should equal out to the correct value, only to learn that most of their money went toward interest. Demand letters and claims tended to go away quickly upon faxing over that page of the statute. For anyone curious why the annual interest is 43% rather than 36%, you calculate compound interest in the formula of cost equals P1 plus I, N1, where P is initial purchase amount, I is interest rate, and N is the number of compounding periods. In our example above, this would look like equals P1 plus 0.03, 12, 1 equals P, 1.03, 12, 1 equals P, 1.425760891 to 1 equals P, 0.43, then you just plug in the initial purchase value for P. And you're good to go. Basically, compounding interest means that you gain interest on interest. For example, if the car cost $10,000 for the initial value, with a 3% compounding interest monthly, the first month's interest would be $300, 3% of $10,000. However, the second month it is calculated as 3% of the $10,000 plus $300, so 3% of $10,300 would now be $309 in interest. Then the next month would be 3% of $10,609 and so on and so forth. Basically, you not only charge interest on the initial cost, but also factor in the additional interest as it grows, or compounds, over time. You can also think of it in reverse, like investing in a stock that pays dividends that you reinvest in the stock. Say you invest $100, and they guarantee a 10% yearly dividend payout. So after the first year, you get a $10 payout, 10% of $100. You reinvest your dividends back into the stock, so you now hold $110 worth of that stock. At the end of year 2, you get that 10% dividend payout, which is now $11 this year, 10% of $110. Then you reinvest those dividends, and get a larger chunk next year. While you still get a 10% dividend, the actual amount of money you receive is higher than just 10% of your initial investment, as you are gaining interest on your interest, dividends on your dividends. Story 5: I got a pro bono client's removal by USCIS canceled. He had a low-level drug possession conviction from the early 1980s. During that brief period, the active ingredient of Imodium was illegal under state law but not federal law. So I successfully argued that they couldn't prove it wasn't a conviction for possession of a substance that was federally legal at the time, and as such was not subject to removal. The argument worked and my guy went back to his business and his family. Story 6: I remember we had to do a trial for the big bad wolf over murdering the 3 little pigs in 5th grade. The teacher's husband was an actual judge and showed up to run it. I was representing the defendant and very passionately argued that my client was a wolf and thus immune to prosecution, and that this case needed to be examined as a loss of livestock rather than murder anyway, the part suggesting that my client could simply be shot as a danger if she threatened livestock but couldn't be brought to court was rather controversial. Story 7: I had a client with a serious medical problem that cost her her job, and she was preparing to file bankruptcy on the medical bills and credit card debts. Thing was, she had like $15,000 socked away and didn't tell me. It was all that was left of her life savings. Before we filed her case, she gave it to her mom for safekeeping. What she didn't know is that she could have kept the money through the bankruptcy, but giving it away beforehand is a no-no. I had to tell the court when I found out, and when this happens, the court gets the right to sue the mom for the $15,000. The thing is, the mom's debt to her daughter's bankruptcy court also dischargeable in bankruptcy. So the mom filed bankruptcy too, and they got to keep the money after all. Story 8: I won a case where the defendant, New York City, tried to exploit a really stupid law, which I was able to use to win the case. This was a slip and fall case where my client had tripped on a piece of broken sidewalk outside of the Natural History Museum and shattered her arm and wrist. The law is that a property owner is responsible for the sidewalk directly outside of their property, the theory being even if they can't fix it, they have a duty to warn people about hazards and mark the area off. The museum was owned by the city. There's another concept called sovereign immunity, which is that governments can't be sued without their consent. So the city had passed a very, very stupid law that they would be exempted from the rule that they can't be sued for sidewalk injuries unless you can show they were on notice of hazard. Meaning, you would have to show that you informed the Secretary of State, Governor, Mayor, etc. of the exact specific crack in the sidewalk before the injury occurs, and you had to do so in writing with ample time for the city to remedy it, 180 days in advance. IRC. Under normal circumstances, This is impossible because no one anticipates tripping on the sidewalk 180 days in advance with the foresight to write a letter to the mayor about that specific crack. Luckily, someone did have that foresight. And there was a nonprofit called Big Apple Maps which would go around the city and with maps of government property and record with insane specificity each and every crack in the sidewalk, pothole, protrusion, and other hazard, and then publish these maps. While serving copies on the government, with the express purpose of combating sovereign immunity defenses in slip and fall cases against the government. I got a hold of one of these maps and visited the site, and I was able to take pictures of the section of the sidewalk where my client fell, and you could see newly placed concrete over the area in the exact position indicated on the map, showing where the sidewalk had been repaired after my client slipped. Basically, the government's attorney brought up the sovereign immunity defense and outlined all of the stupid steps I would have needed to go through to overcome their motion to dismiss. My response was, "Oh, you mean this," and gave them the map. Immediate settlement. Had a friend trip over a huge crack in a sidewalk. The city tried saying they didn't know. I had submitted pictures and a complaint about the crack almost a year prior. He was very thankful I did so as it basically won his case. Yup, for everything, bike got stolen in a big city. No, the cops aren't going to come dust for prints and have a detective work the case. They aren't even going to come to the scene, but filing the report does many things, forces them to include it in their crime stats. If enough people do this, that's how you get some sort of bike theft task force to set up bait bikes and catch a few people. If they do randomly bust a bike theft ring and recover a van full of bikes, you might actually get yours back, especially if you saved a picture of the serial number, rather than it ending up at a police auction and getting resold. If you find your bike, it is 10x easier to do something about it. See it locked up on the street a year later. See someone selling it on Craigslist. Call the cops and bring up your police report. It doesn't take very long to file the report, and don't let them try to talk you out of it. Sometimes they don't want to bother with the paperwork because of reason number 1, it makes them look bad when there's more petty theft in the crime stats. Story 9. There was a case here in Hawaii that got thrown out like this. Someone got pulled over because the police saw she had way too many passengers in the car. Then they noticed she was drunk. Open and shut case. Well, apparently in Hawaii, there's no law defining the maximum number of passengers in a private vehicle, so the issue was that all the extra passengers weren't wearing seat belts. Well, this failed also, because the law only says that every available seatbelt needs to be in use. If you have 6 passengers and only 5 seatbelts, there's nothing at all illegal about the 6th being unrestrained. So, since there was no probable cause to pull her over in the first place, even though she was indefensibly drunk, the whole thing got thrown out. Hawaii has some very counterintuitive laws. If your truck has seats installed in the bed, your passengers must be buckled up. If not, they can just party back there, while anyone in the cab unbuckled would get you a major ticket. People regularly ride down the freeway in truck beds while sitting in lawn chairs. I had a roommate who got picked up for public intoxication one St. Patrick's Day. He was in jail for a couple days, which seemed odd for a PI. Turned out he had a warrant from another city for escaping jail. The year before, he got picked up for public intoxication on St. Patrick's Day. He had a hazy memory of being shuffled down a hallway with a bunch of other drunkards at the jail before walking through a door and suddenly being alone outside. From there he just walked home. The police never came looking for him, so he wasn't even sure it happened. Anyhow, it turns out they never even properly booked him, so while there was a warrant for him escaping jail, there was no record of him ever being arrested. Case dismissed. Living in and can confirm. And this sometimes ends predictably. Happened to a guy in the next town over pretty recently. Riding on the back of a truck, fell off, hit his head and died. Our dare cop in elementary school said that was his worst moment of doing stupid things while on alcohol/drugs. He claimed that while in college he was pre-gaming at a friend's house and had been drinking for several hours when he and a few others rode in the back of a pickup to the stadium. The driver turned a little hard and the cop flew off and rolled down a small hill. Fortunately for him, he only broke a leg and dislocated his shoulder. Story 10. I have one where we won, but didn't quite go as planned. I had a client a while ago who was incarcerated at a state prison farm. Inmates had to spend 40 to 60 hours a week preparing slop for the hogs from expired restaurant food, and cleaning the hog barns. He reeked every time I met with him, even after showering. He said it was miserable. Well, he found out that some Muslim inmates, who couldn't work with pigs, were offered to be able to work at the police horse stable instead, 5 minutes down the road. He wanted to sue, saying that stable work is much less revolting than hog work, and that this amounted to unequal punishment on the basis of religion. I thought he had a point. Well, the case didn't get thrown out and actually got some traction, but then the prison changed their policies in response. Inmates who couldn't work around pigs, or didn't want to, would instead be transported to a factory chicken barn the next county over for work each day. He asked that I drop the lawsuit, and the Muslim inmates were not happy with him. Story 11. I have one where we won, but didn't quite go as planned. I had a client a while ago who was incarcerated at a state prison farm. Inmates had to spend 40 to 60 hours a week preparing slop for the hogs from expired restaurant food, and cleaning the hog barns. He reeked every time I met with him, even after showering. He said it was miserable. Well, he found out that some Muslim inmates, who couldn't work with pigs, were offered to be able to work at the police horse stable instead, 5 minutes down the road. He wanted to sue, saying that stable work is much less revolting than hog work, and that this amounted to unequal punishment on the basis of religion. I thought he had a point. Well, the case didn't get thrown out and actually got some traction, but then the prison changed their policies in response. Inmates who couldn't work around pigs, or didn't want to, would instead be transported to a factory chicken barn the next county over for work each day. He asked that I drop the lawsuit, and the Muslim inmates were not happy with him. Story 12. A guy got drunk and decided to ride his horse through town. This was a small town in North Carolina. Well, he would stop at each intersection and fire his pistol in the air like some Wild West cowboy. Anyway, the guy was charged with a DUI and discharging a firearm within city limits, which was a felony. So, as one would soon find, it is not just mandatory but a law that you must fire your firearm into the air at an intersection when coming through town on your horse. An old blue law that never got erased. He still got the DUI and his horse got impounded, but the dumbfounded judge dropped the other charges. Story 13. Over 10 years ago, I had been at fault for rear-ending someone else. I had no insurance and my license had expired. I don't think I need to mention that I was in a very destitute, low place in life, struggling with almost every conceivable aspect of living. The cop was very kind as we talked, but wrote me a ticket for it all. One was kind of a fix-it ticket about my suspended license. I sorted that out in the days after and nothing came of that ticket. The cop had mentioned that he had to write the insurance ticket, but to take it into court and get it lowered. I was desperate to try and get my $800 insurance ticket lowered because I couldn't afford something like that. So I took the cop's advice. I went into traffic court weeks later, and when it was my time to chat with the judge in front of everyone there, the judge looked at the ticket, stopped me and said, "I would like to use Mr. South Seattle's case as an example to the gallery." I almost died. He went on, "This is a court of law, but it is also a court of fairness. It seems as if the officer didn't write the date of the incident in the ticket. I can't hold Mr. South Seattle accountable to this." My jaw dropped. I stood there. The judge told me I was free to go twice before it registered. I'm pretty sure that cop deliberately didn't write the date on that ticket. Thanks, officer. I had a very similar thing happen. I rear-ended someone, but it turned out the person I hit had a warrant for their arrest. While other cops were taking care of that, another came over to me and gave me a ticket. While he did that, he flipped it over and showed me the instructions to fight it in court. Well, I followed those instructions, and when I got to court, the officer had a family emergency and wasn't able to go, which threw out the case and also my ticket. Thank you to whoever that was. Story 14 inches 2016. Prison inmate John Modi was charged with escaping from the prison in which he was incarcerated, which is a crime in Ohio. The prosecution, however, failed to establish that the Hocking Correctional Facility, and therefore the crime, was located within the court's jurisdiction of Hocking County, as all witnesses potentially able to offer testimony on the prison's location had gone home for the day, and, incredibly, no one remaining could provide references allowing the court to take judicial notice of the prison's location. The charges against Modi were dismissed, and he was allowed to return to prison to serve his sentence, but at least without additional charges concerning his alleged escape. I had a family friend, old guy, passed away now, who said that he was able to escape from prison, and because he escaped, was let go because no one was supposed to be able to escape from that prison, or something like that. He sometimes told stories, but the few things he told me about his crimes, major theft, I didn't believe, but later saw the court papers and they were true. He was a jailhouse lawyer and had a whole bookshelf of legal books. If anyone would be able to research and tell me if it's true, PM me and I'll give you his name because I'd love to know. I don't recall which prison it was, although I know he was in Arkansas for at least part of his stay. Edit. Someone is looking him up for me. I'll update if there are any results. Story 15. Not a lawyer, but I did enough law research to get myself out of a parking ticket one time. When I was in college, I was in the marching band. We had a storage room in the basement of one of the dorms. I was going to get something out of the storage room and parked in the loading dock behind the dorm. There was just enough room next to a dumpster to fit my car. I didn't want to spend $5 on a loading zone pass from parking services, because I was a broke college student, so I just parked. I was only going to be 2 minutes anyway. I finish picking up what I need to. Sure enough, I come back out to my car to a parking ticket. Except it isn't the $25 ticket for parking in a loading zone, it's a $75 ticket for parking in a fire lane. WTF, there was a single sign at the very front of the side road leading up to the loading zone, but no curb paint, no indication of where the fire lane started and where it stopped. I called parking enforcement telling them this and they wouldn't budge. Fine, I took pictures of the loading dock, and I submitted an information request to obtain the evidence pictures. I got the pictures and started researching fire lane requirements in the state. What I found clearly indicated that curb stripes were mandatory. I called parking enforcement and told them what I found and they still wouldn't budge. Frustratingly, I looked at the law again. The part they cited me for said that nothing could obstruct a fire lane at any time. I looked back at the evidence photos and saw the dumpster next to my car. If this was a fire lane, then the dumpster was blocking the fire lane too. The same state law they cited me with said that non-vehicle obstruction of a fire lane was subject to a fine of $1,500 per day. I found satellite imagery from 4 years prior showing that the dumpster had been there for at least 4 years. So I argued to university parking enforcement that if this was a fire lane, then the university had been obstructing it for at least 4 years and would owe the state $2.2 million in fines if I reported it. The parking ticket disappeared immediately when I sent the appeals committee their own evidence photos, sat imagery, and the same state law they cited me with. I drove by a week later and the dumpster was gone, the curb painted, and 2 brand new fire lane signs were up. Dr. got parking ticket for parking in a fire lane at my university. Successfully argued the university owed $2.2 million in fines to the state if it was really a fire lane. $75 parking ticket dropped. Story 16 had a case where my defendant/opponent filed an appeal from an administrative agency to the local circuit court. The requirements for filing the appeal are very strict, and the filing must include an appeal bond, executed by the individual defendant, or a corporate officer. When my opponent's assistant electronically filed the appeal. She attached a .pdf of the bond without the corporate signature. There's no question in my mind they had the bond with the requisite signature, and simply attached the wrong version of the document to the filing. Wish I could say there was a huge court fight over this, and I got to slam my opponent, but that's not how this works among professionals. I waited until after the time to correct this error had passed. I then politely called my opponent, told him that I was holding the I win button, and that I'd be filing a motion to that effect in a week. My opponent came to me with very favorable settlement terms within days. To this day, I don't know for sure if my opponent ever disclosed his mistake to his client. But I doubt it. Story 17. Typical IANL, but the first and only time I ever used the subway station's emergency door to get to the train, the ticket gate wasn't working. It was 3 a.m. I was a drunk college kid trying to catch the last train home. I got caught by 2 subway officers and given a ticket with a huge attempted fare avoidance fine. I showed up to the hearing in desperation, and they ended up having to drop the fine as they were reviewing the case with me because one cop had recorded that I entered through the right-hand emergency door, and the other wrote that I entered through the left-hand emergency door. Never been so grateful in my life. Story 18. Once won a case that forbade the possession or transport of human urine in order to adulterate a urine screen. It wasn't human urine. It was fake lab-made urine from a website. Edit, realizing I kind of messed up the phrasing here. I had a client who was caught with a little container of alleged urine that he may or may not have been about to use to mess up a drug screen. Since he hadn't messed with a drug screen or actually tried to mess with one yet, he couldn't be charged with that, so he was charged with trying to transport human urine with the intent to adulterate a urine screen, meaning, I got to argue that 1. The prosecution hadn't proven it was human urine, they hadn't tested it. 2. They deprived us of the opportunity to test it because the officer poured it out before giving the container back to the client. 3. My client could literally testify it wasn't human urine. He's still known around the office as Human Urine Guy. We have a lot of nicknames like that around here: Human Urine Guy, Drywall Guy, Donkey Kick Guy, Fire Truck Guy, Backpack Girl, Cornhole Board Guy. A bonus: the prosecutor got offended because I made a motion to suppress the search of my client based on violation of the Fourth Amendment. Prosecutor thought we'd agreed that the search was good. The search was good based on the facts in the police report. Not my fault that the police officer testified like an idiot once he got on the stand. Story 19. My brother is a lawyer. He got a DUI charge dropped for a client. Guy gets pulled over. Cop asks him to step out to perform the sobriety test after he admits to having consumed some amount of alcohol. He complies, but after stepping out of his car asks the officer if it's okay for him to reposition his vehicle to move it further away from the road because he feels uncomfortable being that close. The cop obliges. Apparently the charge got dropped because the officer willingly let an intoxicated individual operate a motor vehicle. This happened with a guy I know on his boat. He has a huge 65-foot Viking and the cops couldn't dock it, so they asked him to. His lawyer shows up and says the cops made my client dock his own boat after they decided to take him in for DWI. Sober Water Patrol couldn't dock the boat, but an impaired person can. Case dismissed. Story 20. A friend is a DUI attorney in New York and got a case dismissed because the trooper perjured himself. Long story short, it came down to the trooper testifying in open court, under oath, obviously, that he'd witnessed that the key to the defendant's car was in the ignition when the trooper approached him. My buddy asked the trooper 2 or 3 times if he was absolutely certain, and then asked the trooper what make and model the car was. Toyota Prius, and this was the model that didn't have an ignition slot for the key, just proximity detector. Story 21. I once had a client who woke up in the middle of the night to the sound of someone in his home. He retrieved a Colt 1911 from a bedside drawer, walked into his living room and confronted a figure in the dark. The person didn't identify himself but moved towards my client, who fired a single shot that went through the person's shoulder. Turned out it was my client's stepson who had snuck out, been drinking underage, and stumbled home. The problem with the situation was that my client was a convicted felon. Several times over. That meant that while the shooting itself was legally defensible, his possession of the firearm was not. We looked into the history of the gun itself, as our client had indicated it had belonged to his grandfather, who had served in the U.S. Army in the early 20th century. Ultimately, we were able to bring multiple experts in and establish that the gun had been among the very first batch of firearms distributed from Colt to the U.S. Army at the Augusta Armory. Florida Statute 790.001 creates an exemption of firearm-related laws, including the prohibition for felons to possess a firearm, if the firearm in question was an antique, meaning it was manufactured prior to 1918. Since we could establish the history of the firearm to have been manufactured before 1918, our client couldn't be prosecuted for the offense and got out from underneath a potential mandatory prison sentence. Story 22. Early in my career, I had a fairly minor case in which my client's neighbor cut down a bunch of shrubs and small trees bordering their properties because they blocked his view. This really irritated my client, as he wanted his privacy. Now, the monetary damages were actually not that much, and this was looking like a case that really couldn't be economically litigated for what the client could afford. However, in researching the issue, I found a rather obscure law that provides for attorney's fees to a winning plaintiff when a defendant has willfully damaged the border foliage of a ranch or farm. In looking up the definition of these terms, I realized that my client's property actually qualified for the statute, as he used his land for growing a variety of produce for market. Once attorney's fees were on the table, the other side quickly caved and wrote a big check to cover the damages. Story 23. Prior to becoming an attorney, I worked retail for a few months. The way my assistant manager scheduled me, I had to work 10 days straight, including a couple of 12-hour shifts, with no days off and minimal overtime. The way they got around the overtime was by scheduling me the last 5 days of one week and the first 5 days of the second week, so I only worked 40 hours in the work week plus the 4 hours of overtime for the 12-hour shift. That did not seem right to me, so I looked up the law in Virginia. While they could technically do that, there was an archaic law at the time in Virginia that stated if a non-essential or non-managerial worker wanted Sundays off, the job had to give the Sundays off without penalty. This was true even if the worker agreed in accepting the job to work on Sundays. The worker, under the law, could change his or her mind and ask for all Sundays off. As long as the worker was not essential or a manager, then the employer had to accommodate. I took the law to my manager and said that I was not going to work Sundays anymore. He said that they wouldn't schedule me that many days in a row anymore, but I still had to work Sundays. I told him that I did not and gave him the statute. It caused a big stink, and I ultimately found a better job not long after, but I never worked a Sunday there again. Ironically, a few years later, the Virginia General Assembly accidentally created a law that nullified the essential worker and manager bit of the Sunday law. That made the news, and suddenly people were aware of this archaic law that they could ask for Sundays off. I remember the news saying that no one knew about this law, because I thought to myself, I did. The General Assembly repealed the entire law about Sundays, so now workers do have to work Sundays. That was the only time, though, that I found an archaic law to help me out. Story 24. But I have a story from Australia. I received a letter from SDRO, State Debt Recovery Organization, stating that I had unpaid debts. They gave me 30 days to pay them, otherwise they would be arriving at my home to repossess everything I owned. This included furniture. Furniture was specifically mentioned in the notice. This really pissed me off. I've never had unpaid debts. In addition, I lived in an apt with my brothers, who were these clowns to threaten they would take all my furniture and belongings with 30 days' notice. When I checked the details of the notice, it was for unpaid traffic fines from more than a decade ago. The most recent notice was from 13 years ago, the oldest was from 15 years ago. With interest and other penalties, they wanted a couple of $1,000s, big money to me at the time, 20 years ago. Now, when I was in my early 20s, I did have a motorbike, and I did rack up a few speeding fines, but I paid them. Back then you had to pay them, because if you didn't, your license got cancelled. My license had never been cancelled. I paid the fines by money order. After about 5 years I got a new wallet, looked at the stubs for the money orders, laughed at myself for being paranoid and threw them out with my old wallet. Surely Noon would want them by now, and a few years later these notices arrived. I called SDRO to say these charges were invalid, they had been paid years ago. They said no problem, we just need a letter from the issuing authority to say so. I checked, the issuing authority no longer existed. It had been closed down years ago and a new government authority, the RTA, now existed. I called the SDRO back and they said, sorry, but unless the relevant authority says the debt has been paid, we cannot cancel. But the relevant authority no longer existed. This seemed Kafkaesque to me. I then called the Sydney Central Court. One of the clerks there took pity on me and gave me a huge tip. When they shut down the old government authority and started up the new one, they had of course had to transfer records from the old one to the new one. She thought my payments might have been made at the time of the transfer, and somehow not been recorded on the old system or the new one. My first clue. I contacted the SDRO again and told them I believed these debts had been paid, and been accidentally resurrected in the course of switching systems. This time one of their lawyers wrote to me and said I had not proved this was the case, true, and that the debt still stood. And here is where I had my moment of genius. I told him the debts were paid. And because 7 years had expired, I no longer had to provide proof that I had done it. In the next letter he told me that, because the debts were for traffic offenses, they became a criminal matter, and did not expire after 7 years, and still stood. My next letter, I told him it only became a criminal matter if they were unpaid. However, I said they had been paid, therefore they were no longer a criminal matter, therefore I no longer had to supply proof they had been paid. His next letter you have to prove they have been paid, until then it remains a criminal matter. My next letter, as you are claiming a debt against me, I have to prove they are unpaid. Instead, it's up to you to prove they were. In fact, because the debts you are asserting are so old, there has been a denial of natural justice. The law says I have to retain receipts for more than 7 years, but by trying to collect on a debt so old you're trying to force me to supply proof that according to the law I no longer need to have. From there, I escalated things to the ombudsman, and I won. Or the ombudsman did. The debts were cancelled or assumed to be paid off. I'm glad I won in the end, but can you imagine receiving claims for debts more than a decade old? How ridiculous and unfair. Now 30 years later we have robo-debt in Australia, and I suspect it is illegal to try to force people to prove things about their income from more than 7 years ago.